Presentation today. The presentation today will consist of two sections, a VAWA plus a Q&A session, and then the T visas, U visas, followed by another Q&A sessions. Please, because of the group size, we ask that you drop your questions in the chat, and they will be answered during the Q&A portion. Thank you, everyone, for joining. We are very grateful you're here today. My name is Gwendolyn Margel, and I am the Immigration Legal Services Director at Latinos Progresando. We are accredited by the Department of Justice, and we focus on providing affordable, high-quality immigration services to thousands of families every year. This training is brought to you by the MSRN Community Response Committee, which is co-chaired by Erie House Executive Director Cristina de la Rosa and Latinos Progresando Chief Operating Officer Marcy Gonzalez. Today's presenter is the respected attorney Giovanna Valdez. Giovanna Valdez is a founding partner of Valdez Vilim, LLP. She focuses her practice in the area of immigration and nationality law, including family-based immigration, humanitarian immigration such as asylum, VAWA, U visas, T visas, and the SIJS, naturalization, immigration appeals, and removal defense. She represents clients with cases before the Department of Homeland Security, the Department of State, and the Department of Justice. Everyone, please welcome Giovanna. Giovanna, take it away. Thank you.
Hello, everyone. Happy Friday. Thank you for being here. We're just going to take a little bit of your time today, and hopefully you're able to walk away with a little more knowledge about the 3 different types of humanitarian relief that exists. Hopefully, not necessarily maybe give, legal advice, but at least be able to, I don't want to say screen, but identify, I guess is the right word, identify folks that maybe are in your circle or clients that maybe are eligible for some relief, and you can send them either to LP's way or to some sort of, immigration attorney. Like Wendy said, I'm going to try to go through these slides, and then we'll take a pause and we'll take some questions from y'all, and then we'll move on with the second session of the presentation. All right. Also, questions that you might have, put them in the chat. I can't remember if you said that, Wendy. You might have said that, but put them in the chat if you do have questions, so we can make sure to answer your questions during the Q&A. All right. So moving forward, we'll start off with our first slide. Perfect. So this is just a little bit of an overview of kind of what we're discussing today, right? So we're going to discuss VAWA. Everyone knows it is VAWA. It's a Violence Against Women Act. It's an act that incorporates relief for folks, for immigrants who have been victims of domestic violence. We're also going to discuss T and U, non-immigrant visas today. So for folks that have been victims of certain crimes and human trafficking. And then just a little bit about the protections, confidentiality that comes with these types of reliefs, which is always, people are always concerned with that. That's a lot of times what scares them and why they don't move forward with these types of reliefs. All right, the next slide. All right, so let's start off with VAWA. A lot of you might have heard of it. I think it's something that unfortunately is being turned into something that it's not. I see it promoted by different attorneys. I hear it on the radio, where it's being, I guess, advertised to be something to encompass certain types of acts that it really doesn't. So the next slide, we're going to talk about kind of what it entails, what it includes. So Congress passed this law to help persons that are victims of domestic violence, are in abusive relationships, and allows them to petition for themselves without needing the help of their abuser. And we're going to talk about kind of the different groups of people that are included in this, but it's a way to obtain protected status, a work permit, and in many cases, residency without having to leave the country. The form that is related to this type of relief is the I-360. That's the form online that is used for this type of relief. Like I said, it basically takes away the abuser from the process. Generally in family type immigration, It's your spouse or your child, petition, or your parent petitioning for you. But with VAWA, you're basically removing that family member and you're able to do it on your own because you've been a victim of this abuse. Next slide. So I mentioned, right, these three categories. So let's start with spouse. So for VAWA, the first requirement is that there has to be, so it's either one of these relationships. The first relationship is a spousal relationship. So the person has to be married to either a U.S. citizen or a permanent resident. If the abused person has a child that also doesn't have status, they may include that child in this benefit, even if the child was not necessarily abused. So that's the spousal relationship, right? Sometimes people ask, do they have to be legally married? I suppose so. Generally, they would have to be legally married. There are a couple of exceptions if, let's say, the person who's abused thought they were married, but this other person maybe never divorced the prior spouse or something like that. That would still be considered a qualifying relationship. Or sometimes in certain countries, a legally binding, I guess, contract isn't necessary. If you've lived with the person for a certain amount of time, it's considered a marriage. So, we would just have to research that to figure out if where they married, it is considered a marriage, even though there is no marriage. But that's the technicalities, right? So just no spousal relationship is one of the categories. The next is the child. So if a child has suffered abuse by their U.S. citizen or permanent resident parent, the child would have to be under 21 when they suffered this abuse, and they do have to file for this before they turn 25. Generally, you have to apply before you turn 21, but there is this like leeway if you can explain why you weren't able to do it. So that's why I say 25 is really the cutoff point. The next type of relationship for VAWA is parent. So this is the one that right now you're seeing it on like everywhere, and Wendy's shaking her head because she knows what TikToks I'm talking about. So this is like everywhere that you will hear, attorneys and paralegals or just random people talk about if your child, misbehaves. No, if your child has abused you is what the standard is. So if you have suffered abuse by your child, son or daughter, I should say, that's 21 already. So examples would be, right, that your child, your son or daughter threatens to call immigration on you, pushes you around, calls you names, humiliates you, that would be considered abuse. Your child not coming home before curfew, your child not listening to you and sneaking out of the house, that's not abuse. That's not abuse. That's just a rebellious teenager or whatever. So just, I say this because I see so many people come into my office and say, oh, I saw this on TikTok. Oh, I saw this on YouTube, that I am an abused parent and I can do VAWA. Absolutely. Parent is a category, but it has to be abuse, which we'll talk about what the standard of abuse is in a second. But just so you know, those are the three relationships. Next slide. Okay, so this talks about what we have to show. What are the requirements for a VAWA? So we just talked about the relationship, right? So there has to be that qualifying relationship. There also has to be, you have to show that you have been a victim of this abuse. So the specific wording is subjected to battery or extreme cruelty in the US by the abuser. So you have to have suffered some sort of abuse, which again, we will go into what is included in that. You have to have resided with your abuser. So at some point resided in the same household. You must possess good moral character. What is that? Who could say? I always describe it as, are you deserving of this? Have you been, played by the rules and not got yourself in trouble? Of course, if you have a couple of things from years ago or, minor arrests or convictions, they might not be an issue. However, you do have to show good moral character for the past 5 years of filing. The next thing is that you have to show if it is a marriage-based, so like a spousal type relationship, then you have to show you were married in good faith. So that you married to be together, to have a life together, right? That you didn't marry just for the green card, is what I'm saying. So that's a requirement only if it's a spousal. If it's obviously based off of a child or parent, then that is not a requirement. Next slide. Okay, so this is, I put in here the actual definition, right, of battery or extreme cruelty. So immigration has tried to describe, right, what they mean by this, and they give these examples, right? Forceful detention, physical threat, obviously threats of physical violence or mental injury, psychological, sexual abuse, exploitation, and they go into, right, these different examples. It also says this isn't all inclusive, right? There could be other things that are not on this list, but would be considered abusive actions or acts of violence. So as you can see, it's pretty broad of what is considered extreme cruelty. Battery, I think we can all agree battery is, right, the threat of harm, right, or injury. Next slide. Okay, so then here's a little more of a, I guess, detailed list of kind of things that we have, when I am talking to somebody and I'm figuring out, is this a potential person that could qualify for this? These are things that I'm usually, my questioning is around this stuff, right? Has this person ever been physically abusive to you? What about psychologically abusive, emotional, verbal, emotional abuse, right? Where they're manipulating them, economic abuse, where they're not giving them money or controlling the finances, right? And really, really minimally allowing this person to kind of support themselves. Sexual abuse needs no explanation. Coercion threats, using children as an intimidation. I think that's a big one. It's so common, unfortunately, of saying, I'm going to take the kids away from you. The kids will never, I'm going to, start putting ideas in the kids' heads against this, against the victim. But I think I always hear it, they kind of keep these abused victims in line or silent by threatening to take away their children. So that is considered abuse. Isolation, obviously, folks that work with a lot of domestic violence victims see this probably all the time, right? Cutting off all family relationships, where the abuser is very jealous or whatever it may be, and doesn't allow this person to basically have a network anymore. They don't have anybody, just the abuser. Using citizenship and residency as a privilege, we also see that, right? Threats to call immigration, threats to have them deported, that's considered abuse. Minimizing, denying blame, that's obviously manipulation, right? Always blaming the victim that, because of this, I'm doing this to you. You deserve it. You made me do it. And then we get into these also ugly things, right? Rape, molestation, things like that. Those are also considered violent acts that would be considered extreme cruelty. These are the things that you're kind of looking out for if your clients are telling you about something that happened, or you have a suspicion, right? These are kind of the things that I would look for to figure out if maybe they are someone who would qualify. Next. Okay, so this, I think we're all creative folks. I think this is pretty self-explanatory. So types of evidence, right, that you could gather or that your clients could gather to show the abuse. I think the most common, we always say, oh, police records, but a lot of people don't call the police, right? They just are not in a position where they feel comfortable or they can. So police records sometimes aren't available, and you don't have to call the police. There doesn't have to be that type of record for VAWA. That's, I suppose, the nice part about VAWA, that isn't necessary. But let's say police records, if you do have them, protection orders, if those exist, medical records. I have had clients that have ended up in the hospital many times, and even though when the abuser takes them to the hospital, they have to say that something else happened. I fell down the stairs. Something, it's some made up story because they don't want to get the abuser in trouble, or because they're, the abuser themselves is telling the doctor whatever would happen. So even if it doesn't, the medical records don't say was abused by whoever, it does not matter. Just showing that, it's obviously backing up what the client is saying, then that they did this to me and they took me to the hospital, and then we had to lie and say this. So medical records, photographs, letters. I've had clients have like letters from abuser who's now in jail, send them letters still threatening them. So that's, some photographs, obviously if they have them on their cell phone, or someone took a photo of the injuries or property damage that was done by the abuser, witness affidavits, folks know about the abuse, school records. So school records, what we're referring to here is, this is mostly, I think, it's also, I've had it for parents. So abused children at school, right? They have social work, social workers will sometimes get involved, or teachers, when they see that the child has marks or that the child is acting different. So there's sometimes school records that there was an investigation, or that the child said this and this happened. I've also pulled child school records when the child is saying that their mom or their dad, that these things are going on at home, and it's not the abuse towards the child, it's abuse towards mom and dad, right? And so but the school records do say on this date, so and so the child was upset because mom, whatever. So that's what I'm talking about when I say school records. Social media posts and messages, this is becoming more and more common. Sometimes the abuser will go on a rampage online and say crazy things, tag my clients, which is perfect evidence of how insane they are, and the abuse that's going on at home, or in the relationship. So, when I say messages, I'm talking also about like WhatsApp messages, text messages, right? Sometimes with threats or of abuse. Civil court records. So that's kind of similar to orders of protection or divorce records, right? Sometimes people, when they divorce, they leave their abuser in their court records. Sometimes there will be notes about that, or there'll be records of abuse, or it will say in the divorce decree that there was abuse. I have seen that. So that's another way to show abuse. Statements from shelter workers or counselors. I think that's, depending on the situation, if the person's gone to therapy or it has been in a shelter, that's obviously very helpful to show that they have been a victim of this abuse. Expert testimony, that's a little more removed if you're like working with nothing. Expert testimony would be some sort of, I would say, expert in the field who has talked to your client and could diagnose or indicate, yes, this person has been abused. Next slide. What are the benefits of VAWA? So I just kind of told you what the requirements are and how to kind of identify, right, who might be eligible. But the benefits are amazing. So the first thing that happens when you apply for VAWA is, if you were granted, you are put in something that's called deferred action. A lot of times people have heard of deferred action because of DACA. It's very similar to that. It's the same thing, except for it's for VAWA applicants, and deferred action is given on a, I want to say, it's given on a two-year basis, and then it's renewed. I'm lying to you. It's indefinite. It's indefinite until you apply for your residency. So if your VAWA is approved, it's indefinite. You are protected from removal, and you could seek a work permit. So that's the next bullet point here. You can get a work permit that's what you renew. You don't renew the deferred action, you renew the work permit. The work permit right now it used to be 2 years. It has now moved to 5 years. So you renew it every 5 years. And then I think the biggest thing, benefit about VAWA is that most folks are eligible for residency for their green card through this program, and they're able to apply for their green card in the United States without having to leave if their VAWA is approved. Again, you'll know I put little asterisks and I put sometimes, because there are folks sometimes that we only can do VAWA, we can't do their residency for whatever reason because they have other things in their past that maybe, that are, make them ineligible for residency. But that's generally the biggest benefit is the permanent residency. It's a pathway to that. The next slide. Ooh, we're to the end. Any questions about VAWA? And there's going to be a little bit of talk, I suppose, about VAWA at the end, where I talk about the similarities between all the different programs. But any questions specifically about VAWA? I don't know if we had anything in the chat or if anyone hasn't put it in the chat, wants to put it in the chat. Welcome to do it.
Yes. Can you hear me?
I can, yes.
Hi. Yes, I just want to know why is it that some people will have to leave the country, like to until they receive their residence card? Like I heard people say, "Oh, I have to go to Juarez to finish the process." So in my cousin's case, like they told him to go to Juarez and finish his process, and it's been already like over a year and a half, and he's still over there. He's saying they have not, that he hasn't received anything yet, and he has his family here. So and he was here as a child.
Was he a VAWA applicant? I assume not.
I'm not sure.
Okay, so I think this specifically is about VAWA. So for VAWA, for VAWA applicants, they do not have to leave the country. They get their green card here. And so to your question, maybe of, why do some people have to leave? Why do some people get to do it here? So there are certain programs like VAWA, like U visas, like T visas, like there's a program called 245I. So there's certain programs where you can do your process here and don't have to leave to Ciudad Juarez or to wherever you're from. And then there's certain, if you're not eligible for one of these, then maybe your only way to move forward, right, with residency would be going back to the birth country. So maybe your cousin, right, he probably wasn't eligible for VAWA, wasn't eligible for any of these other options. And so that was maybe his only option. I'm going to assume. I obviously don't know his situation, but yeah, with VAWA, you don't have to do
that. Yeah, I really don't know his situation, but like he's been here since a child, and he's got 2 kids. He's got his wife and a newborn, was on the way when he had to exit the country. Yeah, and now the wife is the one going to visit, but they don't know what's going on. So I don't know. I just thought of asking that question, but thank you.
Yeah, I hope he has an attorney who is helping him or somebody, and if there's been no explanation of why he's sitting there, maybe they should hire somebody to be able to look into it and explain why is he sitting out there, right, so long. The other thing that actually you just brought up, which is, why do some people have to leave? Why do some people get to do it here? I should also mention that VAWA, we're mostly dealing with people that are here, right? All of these organizations, I think, that are on these calls are here. But I should mention that if for some reason a client is here, has suffered violence or whatever it may be, but now has left the country and now is abroad, we can use VAWA to bring them back. So just that should also, people should know that just because if they suffered abuse here, they can use that benefit to come back lawfully. So that also exists. Any other questions? I thought I saw some in the chat. I didn't catch them though.
Yes, there's one in the chat. It states, is there an age limit? Example, parent being abused by child over 25?
A parent being abused?
Yes, by a child over 25.
Okay, so let's clarify. So the parent, when the parent is the victim, the child just has to be over age 21. So they're an adult at the age of 21. I think where we're talking about the 25 is if they're a child who's abused and they want to apply for it, they have to apply under 25. But if a parent is abused and their child is 23 and is abusing them, or 21 isn't abusing them. So I think the question is an example of that, right? Okay.
I believe
So
so. That's mhm.
Mhm.
I
Yes.
believe so. That's how it was stated in the chat. I'm not sure. Oh, yes,
Yes.
that was the question.
Okay. So I guess I could use an example. Obviously, I'm not using names or anything, so confidentiality, but I can use an example of a case I have right now. I have a client who her daughter has for many years. I do think there's maybe some mental health issues with the daughter. However, the daughter for his years, since she was probably like 16, has basically tormented her mother, in the sense that she just is, when she gets angry, it's like rage. It's like throwing chairs. It's like throwing glass at her mom. And her mom, unfortunately, is the one that takes the rage. I don't know, there's obviously issues, and the mother is the one that always gets the wrath. And so the daughter has many times threatened to call immigration on her, has cut her with a glass when she threw a glass at her, has cut her on the leg with a chair when she threw a chair at her. And my client has been in therapy for this for many years because she, obviously it's her daughter. She wants to be able to, she thinks her daughter does have maybe bipolar, but doesn't accept it, and yeah, I think that's an example, right, where my client has obviously been abused by her now 28-year-old daughter, who continues to, right, anytime she gets mad, is threatens to call immigration and have her deported. I don't know if that makes sense. Obviously, that's a very extreme. But, you know, when I see these TikTok attorneys and stuff, they're like, they literally say, you know, if your son or daughter isn't listening to you, doesn't listen to you, or your son or daughter has yelled at you, you are eligible for VAWA. That's not how that works. So just be wary, be aware, be aware. Any other questions?
Yes, there's an additional question in the chat that states, currently, how long does the VAWA process last?
Awesome question. I promise you that's in one of these slides, but I will give you an idea. The processing times right now for the I-360, the VAWA is 36 months, which is 3 years, or is it 40? There's a slide. I promise you there's a slide down there where I pulled up all of the processing times for all of the types of cases. The most recent, I believe it's 3 years, is currently what the processing time for VAWA, which is insane. However, what I should mention is that when you do the VAWA case and the residency case at the same time, you get a work permit within 7 months of so you don't wait 36 months, you get one quicker. But if you're just doing VAWA with no residency, then you have to wait all that time to get a work. But you're waiting in the US. So that's you know what? Something I'm going to also mention, when we talked about how long it takes, there's something called prima facie eligibility, which I talk about in the U Visa, but not in the VAWA. So when you are a VAWA applicant, as we just said, it takes forever, right? Those 3 years. But during the time that you're waiting, the government will do a quick little review of your case and say, you're prima facie eligible. And we'll send you a letter that says, we want to approve you. We think we're going to be able to approve you. In the meantime, because we want to approve you, if you have need to obtain for government benefits, you can do that with this letter. So government benefits being like, it helps with like, I think medical, you could do housing. Wendy, I don't know if you know better than I do, the type of benefits, right? You're able to obtain while your VAWA, your actual VAWA is pending, while you're waiting for your approval. And that's obviously to help these victims get out of their maybe horrible situation they're in, to try to leave their abuser. Also an important point. Is there any more questions in there coming in?
In relation to the VAWA, I'm not seeing any additional questions.
Nothing in relation to the VAWA. Okay. Are they things that we could, related to U visas?
Yes, it's a statement in relation to the U Visa.
Okay, cool. So we will address that in the next part. I think it's U visas, right? The next part, is it U visas or T visas?
T and U Visas.
Okay, thank you so much.
Can I ask, well, Giovanna, maybe we can read that statement and see if you can identify it. Yes, we will touch on that. If not, so that way we don't lose it on what it is.
Yes, what is it? Let's see.
Go ahead,
Sure, I can read it aloud.
please.
Yes. There's a possible U Visa case with a client who was in a car chase from gang-affiliated members and hurt their car in trying to flee. Yet this individual does not speak Spanish, and the police report did not include his statement, and he was labeled the offender. Yet this client continued with going to the court hearings for the case, and the victim did not show, and the case and charges were dropped.
Okay, so unfortunately, if this person was named the offender, even though he was not the offender, there's no way in going back in time and trying to edit that. So I don't see that being a potential U visa if the way that the police department has this person is as the offender and the charges were against this person. If I'm understanding that correctly. So that would probably not be, that would not be a U visa.
And Giovanna, we just have one additional question regarding VAWA. It states,
Mhm.
is there any organizations that are helping clients apply for VAWA at low to no cost?
Hey, Wendy, anybody that you might know?
Thank you. Yes, actually, Latinos Progresando will work VAWAs, and we have, yes.
There
So
you go.
reach out to us. We'll, we'll have our information here. Thank you.
Oh, there you go. And there's Ascend Justice, looks like is another one. I think there's probably people on this call that do this type of work. Very important stuff. Okay, so no more questions about VAWA. We'll move forward then with T's and U's. Okay, so next slide. Okay, so T visas are this T stands for trafficking. And so eventually I divide these up, but both of them have very similar benefits and similar requirements. So here I just talk about the benefits of both of them. Both of them give you lawful status for 4 years. And then eventually you're able to apply for the green card residency after 3 years. Obviously, I should have added my asterisk sometimes. So depending on the circumstances, as long as there haven't been anything that has gone wrong from the moment it was filed to residency, that someone has done something that disqualifies them, they should be able to apply for their residency. When a T and a U is granted, you get a work permit. Work permit is valid for 4 years. The beautiful benefit also of the T and the U is that you can include your family members. So you can include spouse, children, and parents if you are under the age of 21 at the time of filing. Unfortunately, some of the U visa is subject to this numerical cap. So what that means is that U visas, only 10,000 are granted a year, and T visas only 5,000. See the giant difference? Yet T visas, they never reach the cap because there isn't 5,000 people applying apparently a year, or being approved, I should say. Maybe they are applying, but they're not being approved. And U visas is reached every year. So what happens? We're going to kind of talk about deferred action in a second, but T visas, there is a big backlog because they only give out 10,000 a year. So then they put people on a waiting list. But just know that for these types of visas, there is a cap. Unlike VAWA, there is no cap of how many people can be approved every year. Next slide. Okay, so we're going to start with the T visa. And the reason I decided to add this, I think originally it was going to just be U visas and VAWAs, but I decided to add this because I thought all these organizations might be coming across the situation. And I would love for them to be able to identify it at least, and you know, tell people to get help if they're in fact potentially eligible. So for T visas, the first step is getting a Form 914, which is a certification by the agency where the trafficking was reported. So I'll repeat that. Person has been a victim of trafficking, they generally will report it, or many times they don't, but they have to report it. And then you would, wherever they reported it, you would try to get that agency to sign a 914. However, this is not required. And many times people get caught up in that and turn people away because the 914 can't be signed. So just, I want to make that clear that the 914 is not required. However, it does need to be reported to some agency of law enforcement, right? So just know that. So that's step one, the 914 or report to law enforcement. The next thing is that obviously you have to meet the definition, right? That you are in fact a victim of a severe form of trafficking of persons. So I'm going to explain what that is in a second in the next slide, but just know you have to meet that definition. The person has to be physically present in the U.S. It says, or at a port of entry on account of the trafficking. So they have to have come here, right? Be in the U.S. based off of, right, that trafficking that occurred. I've unfortunately spoken to a lot of people, and this is kind of the part that sometimes falls apart, that's where I'm like, right, they may be. So just know that they have to be in the U.S. based off of that trafficking. Victim must comply with requests to investigate or prosecute, with obviously the exception of the age. If they're too young to cooperate, obviously that's not a requirement, but they also, you know, if they do, when they report it, and if law enforcement or whatever the agency is requesting cooperation, they have to cooperate. They must show that they would suffer extreme hardship or severe harm if they're returned to their country, and then they have to be admissible to the U.S. or certain things can be waived. I won't get into the technicalities of that, but basically there's certain things that people sometimes have in their past, immigration violations or crimes or arrests or things like that, that could affect, right, being eligible for this. Next slide. Okay, so here we get into the technical the definition. So it means sex trafficking, in which commercial sex act is induced by force, fraud, or coercion, or in which the person is induced to perform such act has not attained the age of 18, right? So if a minor, even has been brought to the U.S. to do this, obviously then maybe coercion, fraud is not necessary because they're obviously under the age of 18. So that's like one, right? Sexual trafficking. Then there's, or the recruitment, harboring, transport, provision, or obtaining of a person for labor and services through the use of force, fraud, or coercion, or for the purpose of basically, right, subjecting them to servitude, debt bondage, slavery. A lot of times people, I think, this is very technical, but sometimes, you see folks that are brought here for the purposes of to be basically servants or to be sex workers, or, they keep them, working and not paying them to pay off their debt of their travel here. That's all, that's trafficking. So try to think outside of the box. If you're like, I think that, I always say, if you think that obviously it doesn't feel right what this person went through to get here and what they were made to do when they got here, refer them to somebody who can maybe try to figure out if we can make them fit into this box of trafficking. But yeah, this is basically the definition of what it is. Next slide. So this talks about the 914 form, right? I mentioned if once a person reports the trafficking, they, depending on the agency, they can try to get this form signed by the agency. Sometimes that's impossible from these agencies, and just know it's not necessary, but this just kind of goes through why, why is this form, how is this form helpful, I guess, to USCIS? it, confirmed that law enforcement was involved, that the victim had evidence and cooperated. Next slide. I put this in here as kind of just like so people maybe on their own time, if they think they might have a situation like this with a potential client, there is a guide. The guide is for law enforcement for them to evaluate, right, if they sign a 914. But I think it's also helpful for people that maybe like don't work in this area at all to understand if their client maybe does fit into this. Again, probably nobody has, if you don't do this for a living, maybe you just want to refer them, right, to somebody who does do this type of work and could screen, right, for this. But I mentioned this guide so that people, if they want on their own time, have access to what is considered for a T visa. Next slide. All right, now we go into the U. So the U visa requirements, they're going to be kind of similar to the T in many ways, but here the first thing is there's a 918 form that is signed by law enforcement or sometimes agencies, right, got some sort of government agency that could attest to the person being a victim and cooperating. So the 918 is the form that's used for the U visa. Now, unlike the T visa, for a U visa, the 918 is required. T visa does not require the 914, but the U visa does require the 918. So that does have to be signed by law enforcement. And also, Wendy, you have seen sometimes how uncooperative law enforcement is, and the horrible wording that they put sometimes in this is not even helpful. So then why sign? But yeah, law enforcement has to sign that the person was a victim. It's a type of crime that qualifies. They did cooperate. Any sort of injuries that were reported. So a lot is asked of law enforcement, and it's obviously up to them how they fill it out. And sometimes we see that they sign it, but they're just not helpful. They're using words that are not helpful to your client, and you already know this is garbage. Basically, this 918, even though they signed it, it's not gonna give us a U visa. Just know that's the first requirement. Second thing is obviously they have to be a victim of a qualifying crime. Then the crime had to have occurred in the U.S. I'm getting a lot of folks asking, right, but this happened to me on my way here. I was kidnapped in Mexico and then No, I mean, those unfortunately don't work for a U. I think generally those conversations, I try to look for a T, see if T visas, they're eligible for a T visa based off of the kidnapping and things like that. But for a U, it has to have occurred in the United States. Okay. Victim has credible, reliable information, which generally, if they made the report, right, if they contacted law enforcement, I mean, that's a given, right? If they're the ones reporting it or talking to the police, they have information about the crime. They have to cooperate. So this is also sometimes where these U visas fall apart, and that's where folks sometimes in the moment, they're so afraid and they don't want the person arrested, or they don't tell the police where they moved or change their phone number. Police tries to contact them, right? And there's no way to reach them. So there isn't that cooperation portion. So like I said, they have to have cooperated with law enforcement. There's different levels of cooperation, I always say, but they have to have at least cooperated with one of the agencies that was involved. The person has to also prove that they suffered substantial physical or mental abuse as a result of the crime. We're going to go through the types of crimes that qualify in a second, but the person has to show that they did obviously suffer, right, as a result of being a victim of the crime. And then the last thing, right, the person has to be admissible, or they have to file a waiver if they're not admissible. So very similar to the T, right? If they, for some reason, have certain immigration violations or crimes, doesn't mean they're not eligible. They'll just probably have to waive them with a waiver. Next slide. All right, so this is pretty hefty list. I'm not going to go through all of them. At your leisure, you can read the different types of crimes that a U visa encompasses. And this isn't like an all inclusive list. There is some things on here, something called a felonious assault, which we often try to fit in different things into what that is. So like armed robbery, I think is the most common probably. Or like burglary, when a person's home and someone obviously comes into their home and tries to rob them. So there's certain things, right, that we try to sometimes, even though it's not listed, we can argue that it fits into one of these other things. Also at the bottom, I remind people, even attempt, conspiracy or solicitation of any of these crimes is also included. And it says substantially similar crimes to the list of crimes. That's what I'm saying, right? Like sometimes we try to argue that there's a similar crime that should be on this list and it should be included. But this is the list of qualifying crimes. Very important probably when you have a client that's a victim of a crime, because I think that's off the process. People are like, a U Visa, I'm eligible for a U Visa. And it's the crime sometimes is, yes, you were a victim, but it's not a crime that's on the list. So then they're not eligible for you. All right, next slide. Okay, so this just talks about the 918, kind of what information it includes. Like I said, the 918 form, the 918 supplement B, is the form that the police, or I shouldn't say police, it's not always the police, sometimes other agencies, whatever law enforcement or government agency is signing the 918, this is the evidence that they include in the 918. So, right, the name of the person, how helpful they were, any sort of injuries, how they cooperated. And like I said, this is so if the police or the agency that's supposed to sign doesn't want to sign, which often happens. In Illinois, we have the Voices Act, which makes law enforcement consider these and has to essentially sign. But in other jurisdictions, like right now, I'm working with North Carolina, Union County, not having a lot of luck. So, sometimes they're just like, no, we don't sign. We don't do these. And if they're not going to sign, then there's no U Visa. Next slide. Okay, so this, this is, I think, the same, this is kind of what I just mentioned, right? They don't have to sign, they want to. There is no, this also says there's no statute of limitations. So if the crime happened 20 years ago, it doesn't matter. The agency can still consider to sign, or you can still file for a U Visa. There is no time limit of when the crime happened and when you have to file, unlike maybe other types of reliefs. Also this mentions, right, like they can say the person is willing, was cooperative. The person doesn't have to continue being cooperative through, let's say, like the court proceeding. If the police is signing, but the person didn't go to court, let's say, to cooperate, the police could still sign, right? You just have to show that the person was cooperative or helpful at any stage in the process. Yeah, I think that's basically what this is. Next slide. This, again, there's also a U Visa law enforcement resource guide, which I also just, included in here so that people know, Google it, right? If you want more information of what law enforcement is considering or what they should be considering in signing the 918, so that you can try to determine, right, if your client in fact will be able to get one or if it's worth requesting one. Next slide. Okay, so earlier I mentioned prima facie, well, this is bona fide, which is very similar. So when you apply for a U Visa, the government, similar to the VAWA that I talked about, prima facie, they kind of give you this benefit even though they haven't approved you. This is similar in this. They put you in this deferred action status if they want to approve your U Visa. So you apply for the U Visa, the government will give it a quick little review. And if they believe that you have met the basic requirements of the U Visa, they will send out a letter that says, there has been a bona fide determination, right, in your favor, obviously, that you are eligible. And this program started, here is the date, June 14th, 2021. This is due to the giant backlog of U visas and how long they take. So if you get this type of letter, that means you are eligible for a work permit, and the work permit is for 5 years while you are waiting for your U visa to be approved. Now, how quickly are these letters coming in? It is all over the map. People that on this call that maybe do U visas could attest to this. I would say it's about 5 years. However, I have seen these letters for cases I filed in 2022, 2021, 2023, which is crazy that I have cases from 2019 that are still waiting for this letter, and other ones that I filed later have been approved. This supposedly, it's supposed to be in some sort of order. Obviously, the ones that filed first should be getting these letters first, but we're not really seeing that in practice. But yeah, that's what the bona fide determination of letter is essentially putting you like on a waiting list, waiting for your U visa. And that takes about 5 years. Next slide. Okay, so this is essentially what I just said, got ahead of myself. So what does this mean? This letter means you can get a work permit, an EAD, which is employment authorization document. It means you get put in deferred action, which means immigration won't take action to remove you from the U.S., right? They are deferring action against you. And then you're on the waiting list, right? It's generally a positive indicator that your U visa. It also, on this slide, I remind people that the work permit based off of this letter is free, $3. So there is no fee for it. You should not be paying for the work permit under the bona fide determination. Next slide. Processing times. Yeah, this is the more depressing part of this presentation. How long these things take. So we talked about, I stand corrected, the I-360 as of 2 days ago, it was at 39 months, not 36 months. So you do the math. That's a little over 3 years for the VAWA. The U visa is taking about 60 months to be placed in deferred action, not the U visa approval, the deferred action. So 60 months is like 5 years. Like I mentioned, the U visa, to be granted your U visa, in practice, we're seeing about 7 to 8 years. This isn't posted anywhere. This is just in practice. Because if we go onto the website for USCIS, which is listed here, they brag about 60 months, but that's deferred action. That's not for the U visa. T visas, you can see the great difference between T visas is 16.5 months, which compared to the rest of them, you're like, psh, it's a breeze, that's so fast. But that's because they don't have that long wait, right? They don't have that waiting list. They never meet the 5,000. They don't meet the 5,000 every year. I put the link here for processing times if people want to look it up themselves, or you have someone who's like, oh, I applied for a U visa. It was like 5 years ago. Who even knows what's happening, right? You can look at what they're taking to try to maybe guide your client a little bit better of how long they still need to wait. Next slide. So this is super important, I think. I don't know about you guys. I always get clients who are so afraid for many reasons, they're for right reasons, I should say. They're very afraid to sometimes move forward with relief because they're afraid of negatively affecting their abusive child or their abusive partner or, whatever the relationship is. So this just reminds people that VAWA, U's, and T's are confidential, meaning there are laws in place where immigration cannot make any contact with the abuser about the person's process, but also immigration cannot negatively go after these people for these things that the victim is saying that they did to them. So it's completely confidential. Even the notices, right? Like the immigration sends you, here's your receipt notice, here's your fingerprint notice, here's your work permit. They send that all to if they have a representative, like an attorney, they send it all to me. They will never send it to the victim's home. And that's again, for confidentiality reasons, that they don't want the abuser or whoever to find out that they're even doing this process. So I can't stress that enough, right? That this is it's a confidential process where immigration is not gonna, tell the abuser that this is happening or that this person has applied for relief. Next slide. Yeah, nice. So this is the part where I'm just giving y'all the information. If you do have clients that their case has been pending for a long time, you're like, oh my God, they've had a U visa for like 10 years and there's been nothing. These are the addresses that you would contact via snail mail. That's right, mail, guys. How you would contact them to inquire about the case. There are like emails that exist. I know we're in 2024, but that's only for attorneys or accredited reps. So if the person is unrepresented, they're representing themselves or don't have an attorney, the only way to contact these service centers where the case is pending is through mail. So these are the addresses and where you would send your inquiry of what's happening with my case. Next slide. I think okay, these are just resources for y'all. And I think LP, you guys are going to distribute this PowerPoint. So hopefully people, if they want these resources, they can pull it up on the PowerPoint. These are, the processing times, how to contact USCIS for these types of filings, the guides that I talked about, right? The T guide, the U guide, policy manual. You probably don't want to read that. That's very boring, but the policy manual's on there that just, defines, right, what is battery and, the definitions that I talked about. They're defined in the policy manual. Yeah, I think this is it. The last slide. Oh, more. Okay. This is actually important. I think this is the last one. This one's important. These are two different links, obviously you see Department of Homeland Security, right? So this is if someone has been a victim of trafficking and they want to report it, these links can go to the webpage and it helps you report it. So if you guys encounter a situation, I think it's an easy way to kind of try to help the person in the moment and report, what has happened to them through this confidential system. Any other questions? I think this is it, right? Yeah.
There was a question in the chat. Would you be able to help us understand why the wait is so long? And also, is there any hope that is delayed might shrink in the future? That this delay might shrink in the future?
Yes. Okay. So let's attack question number 1. So why are the waits so long for VAWAs? Who could say why? There isn't a cap. I don't know. Is it personnel? I don't understand personally why the VAWA wait is so long. The only thing I can think of is that they're just constantly short-staffed compared to the amount of work they have. I also think there has been an upkick in the amount of people that are applying for VAWA because of all these TikTok attorneys saying, or, all these people applying that aren't eligible. But for VAWA, I can't really understand why. But for U visas, there's absolutely an explanation. And that explanation is because there is only 10,000 U visas that the government gives out every year. And there's about probably like 120,000 people that apply. So they can't give out, right, all these 120,000 U visas. They could only give out 10,000. And so what happens is there's a backlog, right, of all these people. They've reviewed their case. They want to approve them. They put them on a waiting list, let them get a work permit while they're waiting, but they can't approve them until there is an actual U visa to give. So that kind of explains the backlog of the U visa grant. Now, maybe your question is, why does it take 5 years to be put on a waiting list for a U visa? That I cannot explain. That sounds like government mismanagement or, personnel. I don't understand why it takes 5 years. This program that came out in 2021 that I was saying, the Biden administration said, oh, we're going to do these bona fide determination letters so that we can speed up, right? People can get work permits quicker. Great in theory, but in practice, it really has not moved along, I think, as fast as they thought. But the purpose was for it to move, to help people get work permits much faster than 8 years. That was the idea, but it's taking like 5. Hope I answered that correctly, what they were asking. Any other questions?
There was something shared in the chat, and it states, I have a client who has received a work permit from a T visa, I believe because their factory was sued for having multiple teens working who were underage. I wanted to ask if they receive their work permits, how hard or easy is it to reapply for a work permit? And can this be helpful to applying for residency through their children who are citizens?
Okay, so let's attack the first part of it. So the first part of the question is, they received their T visa work permit. Is it a possibility to renew it? Well, if it's a T visa one, it's for 4 years, and you don't renew it. What you generally do is you apply for residency, which then you get a work permit based off of your residency. So you need to apply for residency before that T visa work permit expires. If it's actually a T visa, right? And we would know that by the category. But that's my answer to that. You wouldn't renew the T visa work permit. You would apply for residency is what you would actually do. The second part is, would it help these people to apply through your U.S. citizen children if they already have the T visa, I think is what I understood. And yeah, it could. Generally, it's just like, there's so many factors that go into it to determine if in fact that is the best option, or if it's just better to apply for their residency based off of their already approved T. That might be a better option. So I think that to know which option is better, they would have to consult with somebody who does this type of work.
Okay, and there's an additional question. If you are not approved, is there a chance of deportation?
Wonderful question. Under the current administration that we have, Biden administration, that is not a risk unless you are a national security risk. You were denied because it was determined that you're a national security risk, then yes, you are at the risk of being put into removal proceedings. However, if you were denied because it's not a qualifying crime, because you didn't cooperate, because, for other reasons, the current administration is basically going to close your case, deny it, close your case, and put it away at a warehouse, known not to be touched ever. However, you guys know we have election coming up. And what if another administration comes in? Don't want to say any names, but you know what I'm talking about. If another administration comes in, those things can change, right? Those policies can change. We saw them change during the previous administration. There was actually a policy that had never, ever in history happened. And any U visas that were denied, they were ordered to be put, like the policy was put them in removal proceedings. So if let's say we change administrations, I suppose that we could go back to those old policies. And so then I suppose it is a risk, right, of being put in removal proceedings. But I am going to say, when you are in removal proceedings, it's not like you're removed, you're deported tomorrow. There is a whole legal process that takes place, right? You generally have the right to defend yourself and things like that. Hope that answers that question. Any other questions?
Yes, there was another question that states, what happens with a U visa derivative with a notice to appear?
So if a U visa derivative has a notice to appear? Is that what they mean? Let's pretend that's, if they answer, great, let me know, interrupt me. But if, let's say, a U visa derivative has a notice to appear, that does not affect a person could still do could be a U visa derivative and have a notice to appear. Generally, if the notice to appear does lead to court, right? Court in an immigration court, then we probably have to do some things in court to make that court case closed out based off of the fact that the person is a derivative on a U visa. Sometimes people are a derivative on a U visa and have a notice to appear, but don't ever have court. And that's fine. That's cool. If you don't ever have court, then that's great. You don't have to contact the court to do anything. But if you do have a court case, you also are a derivative on a U visa, you probably want to make that connection and make the court aware so that that court case is closed.
Okay, and we have another question. If someone is an indirect victim of a crime, can that person apply for a U visa?
Yes. So indirect victim is a little bit of a complicated thing, but yes. So the way immigration is going to define indirect victim is you have to, if you've been an indirect victim, you have to have suffered severe consequences. So like the example they give is like, if you're a pregnant woman and you're walking and then there's a shooting in front of you and you lose the baby, you have a miscarriage because of this. That's an indirect victim. I'm like, whoa, that's very extreme. But that's like how severe the harm needs to be for you to qualify to be an indirect victim, generally. I think the most common indirect victim situation we have, well, not really indirect victim, but it is legally, it's not called indirect victim. They are the direct victim. But like I have moms, right, who apply for the U visa because their child was sexually abused. You think of it in your head, you're like, oh yeah, the mom was the indirect victim. You know, she wasn't directly abused. It was the child. But that's a situation where immigration considers the mom actually a direct victim because her child was abused and she obviously suffered severely based off of what's happened to her child. So indirect victim is a little weird. It's not as logical as we think, we think of indirect victim, maybe this and that, but immigration defines it very differently. So if you think, let's say your client was potentially an indirect victim, I absolutely recommend them figuring out, trying to talk to somebody who does this to see if in fact they could benefit from that. Any other? Oh.
Yes, we have another question asking, can the victims qualify for other services, examples, food stamps and Medicaid?
Yes, yes, yes. So that goes for U visa applicants, and that goes for VAWA applicants. Also goes for asylum applicants, but we're not in that presentation today. But yes, absolutely. Any other questions?
There was a question a little earlier wondering if this presentation is available in Spanish.
It is not. It is not. I do speak Spanish. I could have done it in Spanish. But no, we have it in English.
Okay. And there was another question a little earlier. It states, if a victim of domestic violence applies and has children in another country, are her children also eligible for the visa? How long can this process take after information package is delivered?
Great question. I think what they mean is, and whoever asked this question, please feel free to chat if I'm answering this wrong or got this wrong. But what I understand is if mom has been a victim of domestic, she files her VAWA case, she's got kids, let's say in Mexico, could those children benefit Yes, if they are under the age of 21 when she applies and their age freezes. If it's a U.S. citizen abuser. If it's a permanent resident abuser, it's a little bit different. But I think the starting point would be, yes, she has to obviously include them in her application. She needs to include them in her application regardless, but if they're under the age of 21, I think she would want to indicate, right, that those children, she wants them included. And then what we would do is once the VAWA for the mom who's here is approved, we would do the process to bring those children based off of that approval, because the children their VAWA would be approved as well in the approval notice. And how long does it take? I think is the other part of that. If it's a VAWA takes, we just looked, it's like 39 months, right? So those children can't immigrate under that petition until 39, right? 39 months until that VAWA petition is approved. I hope that's right. That's what they're asking.
Okay, and we have another question. Could you provide an updated list of organizations for clients about VAWA and U Visa? Is there a trafficking hotline?
Yeah, so the two links, I think it was the last page on the PowerPoint has the trafficking, like it takes you to the trafficking hotline. Like it has a number. Yeah, so there's these two links, and it has all the information on how to do that. As far as organizations that do this type of work, Wendy, would that be something you guys are able to? I mean, like we said, Latinos Progresando does this. I think someone who does this as well. As
in Justice and Mil Mujeres, I see.
So I don't know if we want to provide, I leave it to you guys, the organizers, if you guys want to provide like a little list for folks, or if you're just like, jot them down, what we just said.
Yes, we can absolutely do that. And we will do, we will reach out obviously to those organizations, making sure it is okay. But for Latinos Progresando, we will provide Wendy's personal, private cell phone address, everything to everyone here. So I'm just kidding, Wendy. We will not do that.
Any other questions? You guys got some good questions.
I'm not seeing any additional questions in the chat. Nope.
Okay, well, for any further questions, Monse has displayed here this information that we will be sharing for. I know there was a couple of questions that were going back and forth. Will we be sharing the presentation? The answer is yes. We will be sharing these resources that are on the presentation. But if tonight, tomorrow, maybe Monday, there's a question that comes up related to the topics that we have Giovanna has discussed here, please feel comfortable to share us an email, and we can compile. We will, if there are any questions that come up, we will be sharing them with the group later next week. And we will do that, not because we don't want to share that update right away, but we want to allow everybody to take this information back. Perhaps somebody asked a question that we didn't think about today, but we will allow you some time to think this through. Send it to Monse at msrn at latinospro.org, and we will have this try to do the best that we can to answer it. I think, Andrew, you have a question?
Yes, we will be meeting again next week.
Will we be meeting again? No. I apologize. I meant we're just allowing next week for anyone to provide any questions that may come. That perhaps I didn't think to ask this, but I would love some, this. We're allowing that time. But no, it won't be a meeting. It'll just be through this email that is presented here, msrn at latinospro.org. But thank you for that.
Thank you.
Okay, well, if there are no further questions, I would just like to take a quick minute to thank Giovanna for a fantastic presentation. Thank you for making the time to bring this information to this group and keeping us all in the loop of what's happening. Fantastic. Would also like to take, even though the co-chairs for the community response, this training is brought to us by MSRN's community response committee, and very important that we send a thank you to Marcy and to Christina for the work that they did in helping us put this together. And we would definitely like to thank each and every one of you for making the time to be here with us. And I just want to say that we will have Monse will be sharing a survey on this chat. We would love for you to open it. We would love for you to provide us your feedback. We would love for you to tell us what is it that worked, what is it that did not work. We don't take offense to that. That's valuable information. We want these trainings to continue. We would love the trainings to be as productive for you all as possible. And we're always open to adjusting anything and everything that we can to make it worth your time and that of your organization, because we understand that this is a commitment that you make to come here, and we want to make sure that we provide you with the best. Andre, I think you have a question.
Yes, is there a way you could send that survey to our email address? Make it just a wee bit easy, will you?
Yes, we will definitely send that. Thank you. So that is coming your way. That will be sent through MSRN, which is Monse here. And again, I would just also like to thank Monse for putting all this together. There was a couple of things that needed to get us to this point. Thank you for that, Monse. A lot of work, but we appreciate it. And again, just the questions. If there are any questions, please, MSRN at latinospro.org. We're looking forward to you all. And thank you so much for making time to be with us. I know it's Friday, and we appreciate you all very much. Giovanna, again, once again, thank you. Thank you so much for the time and for how easy you made it to get us to this point.
My pleasure. My pleasure, guys. Have a beautiful weekend.
Thank you, everyone. Have a great weekend.
Bye.